Oh, and welcome to Self-Represented in Family Court. Your host, Tracy B. That's me. So, dear, we discuss strategies. Yes, strategies and how to use them to get the results you want in family court. If you're self-represented, pro se, pro per, or if you have an attorney and you just need to know what it takes to get through this complex family court system we have, this is the place to be. We discuss strategy. We discuss tactics. We discuss tips and tricks. We discuss techniques. We discuss secrets. We discuss it all. Whatever it takes to get you the strategy that you need, that's it. That's here. That's what we do. So sit back, take notes, and kick ass. Hello there. It's me, Tracy B. And you're listening to Self-Represented in Family Court. This week, I wanted to talk to you about some of the things that you should look for, the errors you should be on the lookout for, the mistakes, whatever the basis is for your disputing, denying, or doubting if the other party's petition or motion are correct or valid or meeting court procedural rules. Now, it's not unheard of to be on the receiving end of several petitions or several motions or other legal documents when you're embroiled in a divorce or custody case. And you can be the petitioner or the respondent and still be the one filing motions or having motions filed against you. Same thing with petitions. There could be several petitions and a numerous amount of motions, discovery, subpoenas, whatever the document is. If it's something that the other party is serving on you with the intention to get a reaction or a movement or decision or order or ruling from the judge or from you, that's when you need to be aware of whether or not the procedural basis or the factual basis or the substantive basis of what they've served you with are adequate, are sufficient. So let's get started. I'm going to discuss 5 things you should definitely be on the lookout for when you are on the receiving end. I'm not talking about when you are the one filing or serving. I'm talking about when you are the one receiving. That means you are the respondent or the defendant in that, or the one who has to respond, or the one who has to answer, or the one who has to oppose or object or deny. And typically that's in writing. So let's get started. So you've been served with a motion. You've been served with a motion, right? One of the first things you should look at when you receive this motion is the actual caption. The caption is the top of the page that usually says your name or the other party's name and your name as the plaintiff or the petitioner, depending on where you are. And it will be a little V in the middle, and then there'll be the other party's name. And then that's to the left. And to the right, or it depends on where you are. Sometimes it's across the entire top of the page. But then at some point in some space, you'll have the court's information, that is the county, the state, and then you'll have the index or the docket number, and you'll have the name of the motion or the purpose of that motion. That's usually what's in the caption. There might be a little bit more. There may be the judge's name, the opposing counsel's name, if that's the case, if there is one involved, things like that. But either way, you want to look at the caption to make sure all of that is complete. Now, those are procedural things that might not necessarily it depends on what you're intending to do as far as when you're actually auditing this motion. But errors in the caption don't necessarily might not necessarily get your case dismissed or get the motion dismissed, but what it might do is buy you some more time. It might buy you some more time if there are errors that need to be fixed and the other party needs to fix those errors and resubmit the motion. It might buy you some more time. Brilliant. Yes, I know. I'm a strategist. This is what I do. And then the next thing is you want to look at what this motion is for. What is this motion asking for? Because when you look at this motion and you see what type of motion it is, the actual relief that the person is requesting in the motion. And yes, you should get an idea from that first page. You should instantly have some understanding of what's next for you. Because if it's a motion to modify, then you should have some understanding that a motion to modify requires certain things to be argued in that motion. If it's a motion to adjourn or put off a case, because some places you have to do that by motion, then you might know that, okay, I don't have to really get so involved in this motion. I just need to decide if delaying this, whatever the case is, delaying this case is okay, or do I need to deny this request because it's not okay? Time is of the essence. So that's important to know because it'll help you position yourself. It should help you position yourself and plot out what your next move is going to be from a logistical standpoint more. But if it's something that the motion is addressing or requesting something that has to do with a substance or a substantive part of your case, then you might be triggered to say, hey, I might want to get one of those consultations with an attorney so that they can walk me through this. But either way, knowing exactly what the motion is requesting or seeking is important. Pay attention to that because motions can be procedural and they can be substantive. Procedural means exactly what I just said. They might just be asking for another date for this case to go forward instead of the date that's been assigned or scheduled. They might ask for the permission to amend a petition or amend some other document that was submitted. And again, that's procedural. It might have a substantive effect on you, but it's considered procedural. And then a substantive motion is more like a modification request or asking that something that you've been doing the judge orders you to stop, or vice versa. That's more substantive. And substantive motions are usually the ones, as a pro se litigant, that you should be more concerned about. Not to say that you should minimize the importance of a procedural motion, because all motions require your attention. It's just that if it's a substantive motion, you might want to get in your head that you may need to talk to somebody who's going to help you navigate that motion. And once you've ascertained the correctness of the caption, you've identified whether your motion is something that needs your attention immediately and might need you to get some assistance from someone who has some professional experience and expertise and credentials to help you, or if it's something that you can just merely say, hey, this is a part of my strategy, whether or not I can or I should object or not object, respond, not respond. Two different things, right? Once you've done that, then you probably should want to go look at the actual basis of the motion, because some substantive motions don't necessarily require you to get an attorney involved on a unbundled service or consultation basis. Some substantive motions you can probably do if you've done something like them before. If you're comfortable doing research, if you're comfortable making your argument, if you're comfortable putting the motion or the response together, then you may be able to do that without getting a lawyer involved. So you want to look at the details because, for example, a motion to modify custody. A motion to modify custody. That means there's already a custody order in place and the other party is asking the court to change something about that custody for whatever reason. You should know by now that a motion to modify custody in every single jurisdiction in this country, America, requires that there be a showing of substantial or significant change in circumstances. And if you're pro se, you should know what that means by now. If you don't, because this is the first time you've ever been hit with a motion like this, then this is the time to look that up. If you see from looking up what it requires that is omitted, it is absent, it is not included in the motion you received, then you might want to think about what you're going to do about that. Are you going to respond and say, hey, this person did not make a basis for modification? Do you want to respond and file your own cross motion asking the court to dismiss? Or do you want to go to court and just verbally tell the judge this? Again, nothing I say is to be considered legal advice, and therefore I want you to still understand as pro se, sometimes you may need to get the insight of an attorney. Some people choose to do these things completely on their own. Again, that is entirely within your right. Just be sure that you do your research. And when you think you've done enough research, do more research to ensure that you're covering your bases and that you're making informed decisions. Because some things you can correct, some things are not repairable when you make a mistake. If you make a mistake, you'll make mistakes. You're sure to make mistakes. But when or what those mistakes are okay or are repairable should always be a consideration in your mind. Yeah. Look at the actual wording and the language used in the motions. Let me just say this too. A lot of people get really caught up on the lies and the deceit and the fabrications and the exaggerations and the embellishment in motions and petitions. And they allow that to really get them all rattled and frazzled just because they're uncomfortable seeing this in writing. And that is one of the oldest tricks in the book. That is one of the easiest and most used mechanisms or ploys or tactics or antics used, especially by attorneys when they're actually going up against pro se. They do that to get you frazzled and rattled so that you get off track and you maybe overlook the deadline or you overlook some other flaw or error, or you overlook their strategy, or you overlook their tactic, or whatever. So when I'm talking to you about looking at the motion and reviewing it and auditing it, I'm not really suggesting that you put a lot of emphasis on all the lies. That's what family court is. It's a forum where people come in there telling their version of the story, knowing that they've embellished it or they've exaggerated it or they just added things that just really have no sound basis for the facts or the way things actually occurred. So don't get too caught up in that, because again, that is one of the tactics that a lot of lawyers and actually other pro se litigants use against other pro se litigants. Please don't fall for it. The next thing I want you to do is look at the attached documents. Look at anything that they've said that they have proof of, that they have exhibits to support, or they have evidence of. Look at the motion to see what they've attached. Because sometimes, believe it or not, that is not accurate evidence. It's not actually supporting the claim or the allegation that they're claiming that it will support. I recently reviewed a prior client's response that he got from the opposing counsel, the opposing party, to a motion that he filed. And in the first 5 minutes, of course, I looked at the motion to look at those things that I just suggested you look at. But then right after that, right after those three things, the fourth thing I did, as I'm telling you, number 4, is I looked at the exhibits. And in the first 5 minutes, in the top 3 exhibits that this party attached, they were all fabricated. You can tell that she created these documents. You can see the hyperimposition of her adding text to some of the documents to make it look like it was a legitimate doctor's note, for example, or that she attached pictures that were 5 years old so it was, to me, it was clear that she had no basis to dispute what my previous client's motion was about. So she just basically pulled things out of her behind that she thought would substantiate her objection or her opposition to his motion. And the interesting thing was, he didn't see any of that. I did. I caught it all, but it was just interesting. So I suggest you do the same thing. Look at dates, look at the text, look at the sources of emails, look at timestamps, look at names and verify names and credentials. Yeah, look at those exhibits, because those are going before the court. And if those same exhibits are not going to make it in court at trial, then why should they make it into court in a motion, right? Or if they have issues with credibility or perjury or any of those things, then they should not be in the judge's possession at all. And if that is the case, you need to bring that up now. You need to address those things now, not wait until the hearing or your trial. And then the last thing is, because I said I was going to do 5, there's more, but I'm going to stop it at 5. The last thing is deadlines and timelines and dates. You always want to know, actually, that should have probably been up there in the top 3, but I'm a strategist. So for me, because I know what to do and how to do this, I'm always going to look for the substance first, because I know the dates. I know the timelines. As soon as I see the timestamp on the top page, I automatically know how much time there is to respond. But you, as a pro se litigant, you may not know that. You should know. You definitely should know. But you need to know that. You need to know if you have 7 days. You need to know if you have 5 days, 10 days. And you need to know what that means. Is it 10 days to get your response into court and to the other party? Is it 10 days to have them served? Is it okay by that 10th day, is it okay to just e-file it and then deliver it to the other side after that? So you need to know exactly what that means, because if you miss the date, you could actually miss your opportunity to object or to even cross move on that basis, on that specific motion. And if you do that, then the judge can grant them sometimes, not all the times, because again, there's defaults in family court, but it's not the same kind of default as if you are in civil courts. But that doesn't mean that you should ignore timelines and deadlines and response times and similar. It's still very important that you do that. And if you can't do that, to always contact the other party to see if they'd be willing to extend the date, or to contact the court to see if the court is okay with extending the date, or if the court is okay with you reaching out to the other party to come up with an agreement to extend the date for you to respond, or whatever it is you're going to do. So either way, though, it's important that you learn to look at those things, learn to understand that when you receive a motion, no, you're not to go in a frenzy and hyperventilate and get extremely emotional and start to worry and think, oh, I need to hire a lawyer now. I can't do this anymore on my own. And you might do all those things, right? Because you're human, right? But my point is, at some point, you're going to need to calm down and get focused and concentrate, pay attention, and start thinking strategically, right? Whether you decide to get an attorney or not, you still need to do these things for yourself. You still need to understand that making informed decisions start with you right there. You learning to calm yourself down and knowing what's going on, or getting a grasp of what's going on as much as you can, as best as you can, and deciding from there. Not just getting frazzled, hyperventilate, and staying stuck in that energy and deciding, you know what, I give up or I break down completely. Nope, you have to still take a minute, take a few minutes, take an hour, get the documents, look at them, put it down for an hour, and come back to it later. Nothing's major is going to happen in an hour, right? Come back to it when you've calmed down. Come back to it when you're able to focus, when you're able to pay attention, when you're able to really give the time and attention to the document that it needs, when you're able to gather as much information from looking at it as you need to make, yes, an informed decision. That's important, because I'm going to tell you, family court is, the motions are endless. The petitions are endless. They can, if the higher conflict your case is, the more you're going to have these motions and petitions, the more you're going to have other documents, additional documents, amended documents, supplemental documents. Oh, it can go on incessantly. It can go on incessantly. So once you've learned to pinpoint those things, you get better and it gets a little easier. And you learn to respond or react in a way that's not so detrimental to the overall goal of your case, to your overall goal, your overall objective in your divorce or custody case. So that's it. That's all I have for you this week. I hope you found this helpful. I hope you really found some sort of comfort in knowing that, yes, you can do some of these things on your own. You can learn, you can adapt, you can equip yourself with what you need to deal with at least the preliminary aspects of receiving a motion or petition from opposing counsel or the opposing party who might be pro se as well. So if you need help with anything like that, coming up with a game plan, strategizing from the time you receive a petition or the time you receive a motion, helping you get in position, helping you learn to present, helping you learn to focus, helping you learn to implement some tools, helping you understand the tactics and the ploys that the attorneys are going to play, helping you understand the dynamics of the family courtroom. I'm going to stop there. I have a whole list of things that I can help you with, but those are the things that I do provide as a family court strategist, as a pro se family court strategist. And if that's what you need, you can work with me on a 1 hour basis, on a 1 month basis, 3 months, 6 months, whatever you feel is necessary to help you get through this point. And I just want to add this, that even though I specialize in helping pro se, I do work with people who have attorneys. I'm really limited into how much I can do, because once you're represented by an attorney, even though I'm working with you as a strategist / coach, I'm still a lawyer. And so the waters can get muddled. So what I can do with you is really specifically on a practical level, but I've helped so many people who have attorneys better understand what's going on, improve their relationships with their attorneys, and therefore get in a position where they're able to ensure that the results in family court were a lot more favorable to them. So if that's you, either way, feel free to reach out to me. You can always find me on my website or on Facebook or directly through email. My information are in the notes, so just go there, let me know. And until then, I will talk to you soon. We want to thank you for joining us here at Self-Representing in Family Court, where we discuss all things strategy in family court. Join us next time. Until then, visit us at www.thedivorcesolutionist.com.